should a trust, and this is a common question, be named as a beneficiary of a qualified account?
Welcome to Barry's Bites. Please join our host, attorney and advisor Chris Barry.
So qualified accounts are things like 401ks, IRAs, 403bs, really anything pre-tax. And in fact, this is a question I get from not just family members or our clients, potential clients and clients, but also from other financial professionals. And this is one of the things that really frustrates me is the confusion on this topic. And in fact, just before I hopped on this webinar, I saw that I have a phone call scheduled with another client's advisor to educate that advisor on how this works. So the answer is, unfortunately, it depends. It depends on what type of trust that you're creating. Any trust that we create in our office is going to qualify as what's called a designated beneficiary. So this is the key, is that the trust has to qualify as a designated beneficiary. Because if it doesn't qualify as a designated beneficiary, then all the taxes would have to be paid within 5 years. So if you're leaving like $1 million IRA to the next generation and the trust does not qualify as a designated beneficiary, then all the taxes would have to be paid within 5 years. Now, prior to the Secure Act, if we set up the trust in the proper manner, all the taxes could be paid, stretch out over the lifetime. But now because we have the Secure Act, whether we name an individual, like a son or daughter as a beneficiary, or a trust, at most we have a 10-year stretch out. So either way, whether we name an individual or a trust, thanks to the Secure Act, so the Secure Act means that we can only stretch out those pre-tax accounts 10 years, meaning stretch out paying the taxes over 10 years. And that's regardless of whether we name a trust, one of our trusts that qualifies as a designated beneficiary, or an individual. Now, typically we name the spouse as the primary beneficiary so they can do what's called a spousal rollover, where now that surviving spouse inherits that IRA and it becomes their IRA, where they don't have to take out any required minimum distributions or anything like that. But typically we'll name spouse as primary beneficiary and then the trust as the contingent beneficiary. And one of the big reasons why we do that is a lot of times in our trusts, when we build in what we call legacy inheritance provisions. Meaning that if your children were to inherit an IRA, 401k, 403b, post-tax accounts, Roth, life insurance, if they're to inherit and it's one of our legacy inheritance trusts, then whatever they inherit from you would be protected from a divorce, a lawsuit, creditor action, bankruptcy. Very different than leaving it outright to a beneficiary. Plus, if that individual were to pass away, then the money stays in the bloodline versus going to a spouse who might remarry. So for that reason, or two reasons. One is we name the trust as a beneficiary because it will have the same tax implications if we name the individual. And then second, typically when we're setting up a trust, we build in language so whatever the beneficiaries or kids inherit would be protected from divorces, lawsuits, creditors, bankruptcies. And this is something that just for the last 10 years has infuriated me, is that a lot of people who hold themselves out as financial advisors or financial professionals are giving wrong, bad, or just uneducated advice with regards to trusts. And so again, I think the trust should be named typically as a contingent beneficiary if you're married, because we can maintain all of the tax benefits of naming the individual outright, but now we can build in the opportunity for a lifetime of asset protection. So if someone's telling you not to name the trust as a beneficiary of a qualified account, I would be happy to have a conversation with them and educate them on why the trust typically should be named as a contingent beneficiary. Again, we want to name the spouse as the primary beneficiary 9 times out of 10, but then we'll name the trust as the contingent beneficiary for the asset protection provisions that we talked about. Plus, from a tax perspective, it's no different with our trusts than naming individual outright. So there's no downside to naming the trust, only an upside of naming the trust as a beneficiary of that qualified account.